Assalamualaikum and good morning everyone. Today we would like to make a presentation, but before we want to start a presentation, I would like to introduce my team members. Firstly, AFIFAH ATHIRAH binti Ahmad Ghazali, NURSHAFINAZ binti Azizan, SABRINA binti ZAMRI, NURSHAFINAZ binti Muhammad, and me, NURUL KHAIRUNNISA binti Muhammad Yusof. So, our group want to present about question number 2, which is about Shazwani's case. She had made an appointment to visit and evaluate her student who is currently undergoing internship at Kuala Lumpur Central at 3 p.m. on Thursday. On that day, she left the university at 12 p.m. and went to a mall to have a lunch before proceed with her plan to meeting her student. After having her lunch, she went to a cinema and watched a movie from 12:30 p.m. to 2:30 p.m. Then she left the mall and went to Kuala Lumpur Central for the meeting. Unfortunately, she met with an accident and had caused her with a few injuries. So she was not able to come for a month. So she was not able to come for work for a month. After recovered, she made a claim for employment injury scheme, but her claim is unsuccessful. So the issue in that case is whether Shazwani entitled to claim the compensation for Section 24, Subsection 1, Employment Social Security Act 1969, Employment Injury Scheme or not. So I will pass to the next presenter.
Thank you, KHAIRUNNISA. So law that related in this issue is first Section 5, Employment Social Security Act 1969, where subject to this act, all employee in industry to which this act applies shall be insured in the manner provided by this act. In Section 6, Subsection 1, Employment Social Security Act in 1969, the contribution of the second category, being the contribution payable by or on behalf of employee insured only against the contingency of employment injury, while in SOCSO is in charge of two types of social security, which is the employment injury insurance scheme and the invalidity pension scheme. The plan also covers any kind of accident or death 24 hours a day and 7 days a week. Other than that is Section 24, Subsection 1, Employment Social Security Act 1969, also related to this issue, which is an accident happening to an insured person shall be deemed to arise out of and in the course of his employment if the accident happens while the insured person travelling on a journey between her place of work and the place where she takes his meal during any authorized recess. That's all for the law. Next, I will pass to the next presenter to explain about case.
So for the case, Ketua Pengarah Pertubuhan Keselamatan Sosial versus Raja Paras Mewari, anak perempuan Mari Mutu. Facts: a factory worker living in Glugu, Penang, who go to her daughter's house every weekend. Each Monday morning, she would leave her daughter's house and travel to the bus station where the company factory bus would pick up her to work. One day, while making the trip from the daughter's house to the bus station, she was involved in an accident. So rejected her claim for compensation and she applied to the appellate board, which allowed her appeal. So she then appealed the board decision to the High Court. For the head, court examined the words resident and stay and decided that the former mean a place where one lived or had one homes. The word cannot some permanency, whereas to stay somewhere is to suggest a temporary resident. Based on this definition, the High Court decide that when the insured worker left her daughter's house, she was in fact traveling on a route between her place of stay and her place of work. There is the bus station where she would be picked up by the factory bus. Thus, the court decide on favor of the worker. So the next slide I want to pass to Shafira.
Application for this case, based on Section 5 Employee Social Security Act 1969, she met with an accident and had caused her with few injuries during on the way to the meeting with a student. In that situation, she was not able to claim the Employment Injury Scheme under the Employment Social Security Act 1969. Based on Section 24 Sub 1 Sub C, Employment Social Security Act 1969, she went to a cinema and watched a movie from 12:30 p.m. to 2:30 p.m. Then she left the mall and went to Kuala Lumpur Central for meeting, and she met with an accident. Based on what happened to Syazwani, we can relate to the case of the Director General of the Social Security Organisation versus Raja Parameswari Anak Perempuan Marimutu because her social compensation is denied. Because the accident happened after she left the cinema, not on her way to work and without notice. Syazwani can get compensated if she goes straight from the office to the meeting place. Next, I will pass to the next presenter.
For the conclusion in this Syazwani case is Syazwani do not deserve to claim the employment injury scheme because she had an accident outside of her work. So we move to the next session, which is question and answer session.
So I have question for Sabrina. What if Shazwani believed that the employment injury scheme insurance claim back?
Uh, Thank you, Shafinaz. So for the answer is if Shazwani believes that her claim has been wrongly rejected, she can consider appealing the decision. And she may want to review the reason for the rejection and gather any additional information or evidence that may support her claim. So next question.
Okay, next question. I want to ask Afifah ATHIRAH. Why cannot Syazwani get employment injury scheme insurance?
She cannot get the employment injury schemes insurance because that is not sure from the information given whether Syazwani accident was directly related to her job or not. If the accident was not related to his work, then her claim to the employment injury scheme insurance may not be unsuccessful. May not be successful. Any other question?
No.
That's all presentation for our group for this case. Assalamualaikum and thank you.